start, and that as the appellants had not used the said well water at all, stop by way of adverse possession, plaintiffs had become the owners with regard to the 2 annas and 8 pi share in the said well. Stop. The trial court, after considering all the issues, came to the conclusion that the plaintiffs had failed to prove that they had become the owners with regard to the 2 annas and 8 pi share in the said well water by virtue of adverse possession. Stop. The trial court also came to the findings that the plaintiffs had failed to prove their possession of the said sued property in preference to the persons having lawful title. Stop. The trial court also came to the conclusion that mere change in mutation entry does not confer any title upon the respondent numbers 1 and 2 herein. Para. Against the said dismissal of the suit, the respondent numbers 1 and 2 filed a regular civil appeal number 213 of 1987 before the 3rd Additional District Judge at Satara. Stop. The learned appellate court reversed the judgment of the trial court, allowed the appeal, and held that the mutation entry dated 26 September 1983 was based on a sale deed dated 26 September 1951. Stop. The learned appellate court had also directed the present appellants that they should not, either personally or through their agents, servants, relatives, raise any obstruction to the enjoyment of the suit well by respondent numbers 1 and 2 along with respondents number 3 and 4. Para. The lower appellate court had very strongly relied upon various mutation entries and changes therein which were caused by respondent numbers 1 and 2 herein to substantiate the contention of respondent numbers 1 and 2 that as their names have been incorporated instead of the appellants, and that due to the fact that the appellants had never used the well water, the respondents had become the owners by virtue of adverse possession with regard to the aforesaid 2 annas and 8 pi share in the well water. Stop. The lower appellate court had also taken into account that the appellants had not objected to any of the change of the mutation entry from 1951 till 1983, and as such the contention of the respondent numbers 1 and 2 was accepted. Para. It is an admitted position that when the changes in mutation entries were made from 1951 onwards, the present appellants were not given any notice whatsoever in that behalf. Full stop.